a ruling so powerful it shook the foundation of American law, and almost no one saw it coming. While headlines obsessed over politics and celebrity drama, something far more important unfolded inside the Supreme Court. In an extraordinary and unanimous decision, the justices rewrote the legal playbook on one of the most critical protections you have under the Constitution. It wasn't about a technical loophole, it wasn't a minor policy tweak. This decision directly changes how every citizen, especially those who legally own and carry, may be treated during any encounter with law enforcement. The case was Barnes versus Felix, a tragedy at its core, but what the court decided reaches far beyond that single event. For the first time in decades, they rejected the narrow rules lower courts had relied on and replaced them with a standard that demands full context and full accountability. And here's why this matters to you. From a traffic stop to a knock at your door, the way your actions and the actions of those in authority are judged has just changed nationwide. Today on Firearms Law Advisor, we're breaking this down step by step so you know exactly what the court ruled and why it matters to you, how this could reshape self-defense cases, and the critical details every responsible citizen must understand going forward. Chapter 1. What happened in Barnes versus Felix? The facts are stark and fast. In Texas, Officer Robert Felix Jr. stopped Ashton Barnes for suspected toll violations. Felix ordered Barnes out of the vehicle. Barnes cracked the door, appeared to comply, then tried to drive away. In a split decision, Felix stepped onto the open driver's side door sill as the car began moving. About 2 seconds later, Felix fired 2 rounds into the vehicle. Barnes was struck and later died. From motion to stop, the key sequence lasted about 5 seconds. Barnes's mother filed a civil suit alleging excessive force in violation of the Fourth Amendment. The district court granted judgment for the officer, applying a doctrine the Fifth Circuit had used repeatedly, the moment of threat rule. That approach tells courts to evaluate only the instant the force was used. If the officer reasonably perceived a deadly threat at that exact moment, the force is constitutional. Events leading up to that moment are treated as irrelevant, the Fifth Circuit affirmed. It focused on the 2 seconds when Felix was clinging to a moving car and concluded a reasonable officer could fear being thrown, run over, or dragged. Under that lens, the shooting was lawful. Then the Supreme Court took the case and unanimously said, that lens is too narrow. The opinion, authored by Justice Elena Kagan, holds that claims of excessive force during a stop or arrest must be evaluated by examining the totality of the circumstances from the perspective of a reasonable officer on the scene. That test is not limited by an artificial time box. Courts may and should consider earlier facts that give meaning to the final seconds. They may consider whether the officer's prior choices escalated the risk unnecessarily, as well as what the suspect did or failed to do. In simple terms, the Constitution demands context, not a cropped still frame. Chapter 2. The Old Rule and Why It Failed. Why did the moment of threat doctrine take hold? Because use of force encounters often turn on fast decisions. Courts were reluctant to second-guess split-second judgments with perfect hindsight, so they narrowed the analysis to what the officer reasonably perceived at the final moment. The problem was never the desire to avoid hindsight bias. The problem was the blindness that followed. By ignoring what came before, the law sometimes gave a pass to avoidable danger. If an officer's earlier choices cornered both people into a deadly bind, poor positioning, failure to wait for backup, commands that were unclear or contradictory, those choices disappeared from the legal equation. The snapshot could look justified even when the movie showed it never had to happen that way. This is why Families and Civil Liberties advocates pointed to case after case where a person who posed no real threat wound up dead after a chain of misunderstandings. Stephon Clark, Sacramento, a vandalism call, a backyard, a phone mistaken for a gun. Whether lights, distance, or tactics could have changed that outcome was often treated as irrelevant under the old rule. Oscar Grant, Oakland's Fruitvale Station, New Year's Day 2009. Not a shooting by a patrol officer during an active stop in the classic sense, but a transit police use of force that raised enduring questions about training, escalation, and accountability. Grant was shot while prone on a platform. The officer claimed he meant to deploy a taser. The case became a symbol in California of how seconds can define a lifetime. Sean Monterosa, Vallejo. The decision to fire through a windshield from a moving vehicle magnified scrutiny of pre-shot choices. Under a narrow moment test, only the final perceived reach mattered. Under a totality test, tactics and risk creation can be weighed too. Courts needed a standard that filtered out pure hindsight, but still allowed cause and effect to count. That is what the Supreme Court just restored. Chapter 3. The New Standard. totality of the circumstances. The Barnes opinion does not invent a brand new doctrine. It revives the classic Fourth Amendment inquiry, objective reasonableness in light of all the facts known to a reasonable officer, considering the totality of the circumstances. The court makes three pivotal clarifications that now govern use of force analysis nationwide. 1. No artificial time limit. The inquiry may include earlier conduct that helps explain the endgame. Prior commands, positioning, radio information, the suspect's compliance or confusion, the presence of bystanders, and the availability of safer alternatives can matter. Courts are not limited to the last blink. 2. No perfect hindsight. Judges cannot micromanage tactical choices with the luxury of slow motion. The test remains what a reasonable officer on the scene would have perceived and done, given the information available at the time. 3. Causation counts both ways. If prior choices by an officer unreasonably created the danger that led to force, that is relevant. If prior conduct by the suspect reasonably signaled lethal risk, that is relevant too. The scale must weigh everything. Justice Kagan writes that earlier facts may show why ambiguous conduct looked threatening or harmless. That sentence is the beating heart of the opinion. It recognizes that lawful behavior by citizens, especially those carrying legally, can be misread in a fraction of a second, and that courts must account for the lawfulness of those actions in judging the officer's response. Justice Kavanaugh's concurrence, joined by Justices Thomas, Barrett, and Alito, underscores the flip side. Traffic stops are dangerous. Flight can turn lethal for officers and the public. Courts must continue to guard against unrealistic expectations. The point of the concurrence is not to narrow the rule, but to remind everyone that reasonableness remains the touchstone. Take those together, and you get a balanced command to the lower courts. Look wide, think fair, judge in the real world. Chapter 4. Why this matters to gun owners. Now the connection that your audience cares about most. In the last decade, more routine police-citizen encounters have involved lawful firearms, concealed carry disclosures during traffic stops, open carry in states that allow it, home checks related to red flag petitions, and investigations where a citizen is both the reporter and the armed defender. Many tragedies began with a lawful movement that looked threatening to an officer keyed for danger. Under a narrow moment of threat rule, the person's lawful status and prior compliance could be erased by the final instant. Under the totality rule, those facts must be considered. Picture this scenario in a state that requires disclosure. You are pulled over at dusk. You inform the officer you are licensed and currently carrying at the 3 o'clock position. You move to produce your permit as instructed. The officer, amped by a prior high-risk stop, misreads your movement as a draw. A shot is fired. Under the old test, courts might have asked only whether the officer reasonably feared a gun was being drawn at that instant. Under the new test, the court must consider what you said, what you were told to do, what the officer knew, and whether his approach contributed to a misread. That is not a loophole for criminals. It is a lifeline for law-abiding citizens who do everything right and still wind up in a deadly misunderstanding. Real cases illuminate the stakes. In Phoenix, Arizona, 2016, Daniel Shaver, not a firearms case in the carry sense, but a pure lesson in commands, confusion, and escalation, was shot in a hotel hallway while trying to follow a complex orders. The public reaction focused on how instructions and posture can create or diffuse perceived threat. Under Barnes, the totality of those commands and the suspect's efforts are squarely relevant. In California, the Kelly Thomas case in Fullerton, 2011, was not a shooting. It was a fatal beating of an unarmed, mentally ill man. It nonetheless became a landmark in how pre-force decisions and escalation can lead to a death. Though the legal posture differed, Barnes's totality rule embraces that logic for Fourth Amendment seizures involving force. In Cleveland, Tamir Rice, a realistic toy gun, a 2-second arrival. Courts once focused on that last flicker. Totality requires asking whether the approach and information sharing made that outcome far more likely than necessary. For carry communities, the practical takeaways are concrete. Say it early, say it clearly. If your state requires you to inform, do it before you move. Officer, I am licensed and currently carrying on my right hip. My hands are visible. How would you like me to proceed? Ask for instructions and repeat them back. Do you want my permit? I will reach slowly with my left hand into my wallet now. Clear feedback loops reduce misreads and create a record that courts can weigh. Slow is smooth, smooth is safe. Move deliberately. Keep hands high and visible whenever possible. Narrate your actions. Know your state's script. Some states require immediate disclosure, others do not. Know the rule so you're not improvising under stress. Barnes does not guarantee safety. It guarantees fairness in the courtroom afterward by forcing judges to look at the whole encounter. That can save families from losing everything to a misunderstanding, and it can save officers from unfair second-guessing when the total picture shows they acted reasonably. Chapter 5. The Doctrine in Action. A nationwide reset for lower courts. The ink on Barnes versus Felix was barely dry when the legal ripples began to spread. Why? Because the Supreme Court did not just set a guideline, it imposed a mandatory recalibration on every federal court in the United States. For decades, the Fifth Circuit and a handful of others operated under the moment of threat tunnel vision. That ends now. Lower courts must reopen their mental frame wider. Judges who once ruled in minutes on qualified immunity will now have to hear more evidence, review more body camera footage, and consider pre-forced decisions as part of the reasonableness analysis. Real-world impact example. Imagine a case in Dallas, Texas where an officer shoots a driver after a brief chase. Under the old rule, only the final second, the driver reaching under the seat would matter. Under the new rule, if video shows the officer initiated the stop in a manner that boxed in the driver without backup, escalated the situation with rapid, overlapping commands, and failed to verify what was in the suspect's hands. Before firing, those details must be considered. That makes it far more likely that a case will go to a jury instead of being dismissed at summary judgment. This is not theoretical. Federal appellate courts will have to revisit precedents they relied on for years. Plaintiffs' attorneys are already filing motions to reconsider excessive force cases that were dismissed under the old narrow test. Some judges will resist, but the Supreme Court's 9-0 unity makes it clear. Failure to apply the totality standard is grounds for reversal. Even police union attorneys are retooling their defense strategies. They now have to address earlier decision-making in officer reports, not just the final moments. This means training will change too, because departments know every choice leading to a shooting is now admissible to judge reasonableness. Chapter 6. California. Under the microscope, how two cases would play out now. California is a hotbed for debates on policing and constitutional rights. Let's take two high-profile incidents and run them through the Barnes lens. Case 1. Stephen Clark, Sacramento. 2018 police were responding to reports of someone breaking car windows. They chased Clark into his grandmother's backyard. The body camera footage showed officers giving commands in the dark, then firing 20 rounds when they believed Clark pointed a gun. It turned out to be a cell phone. Old rule analysis. At the moment of threat, the instant they saw the object in Clark's hand, their belief it was a gun could be deemed reasonable, ending the case. Barnes analysis. Courts must now weigh whether officers properly identified themselves, used lighting effectively, took positions that minimized misinterpretation, and gave Clark a fair chance to comply. The totality could reveal that earlier tactics created a false sense of imminent danger. Case 2. Sean Monterosa, Vallejo, 2020. During civil unrest, police responded to a suspected looting in progress. Monterosa was outside a Walgreens, allegedly kneeling with his hands near his waistband. An officer still inside a moving, unmarked police truck fired 5 shots through the windshield, killing him. No gun was recovered, only a hammer in his pocket. Old rule analysis. The moment of threat would freeze on Monterosa's hand movement, allowing the claim of perceived danger to dominate. Barnes analysis. The court must now consider whether firing from a moving vehicle without clear identification increased the likelihood of misinterpretation, and whether waiting to stop and issue commands could have reduced risk. Pre-force tactical decisions are now squarely in play. Both cases under Barnes would get deeper factual review. For California, where many police encounters are heavily scrutinized and often politicized, this means more cases will survive dismissal and proceed to trial. Chapter 7. Second Amendment Crossroads. Carry rights meet Fourth Amendment protections. The overlap between the Second and Fourth Amendments has never been sharper. Every year, thousands of gun owners are involved in police encounters, from routine traffic stops to high-tension emergency calls. In many states, you are legally required to disclose that you are armed. The very act of disclosure can set off a chain of reactions. Old rule risk. If the encounter ended in a mistaken shooting, courts looked only at the final perceived movement. New rule advantage. Now, the officer's awareness of your lawful carry status, your compliance with disclosure laws, and the clarity of commands will all be considered. Scenario example. In North Carolina, a man is stopped for speeding. He informs the officer, "I have a concealed carry permit and I'm armed at my right hip." The officer, distracted by radio chatter about a nearby armed robbery, misinterprets the man's reach for his license as a threat and fires. Under Barnes, the court must consider the driver's clear verbal disclosure, the officer's prior knowledge from dispatch, whether the officer gave explicit instructions on how to retrieve documents, the driver's compliance with state law. This does not automatically make the shooting unlawful, but it prevents the lawful disclosure from being erased in court. For red flag law enforcement, this ruling also changes the calculus. Officers serving gun seizure orders must now anticipate that pre-force planning, including time of day, method of approach, and communication, will be scrutinized. Sloppy or aggressive execution that triggers unnecessary escalation will no longer be invisible in court. Chapter 8: Training, Body Cams, and the New Evidence Playbook. The Barnes decision makes one thing clear: documentation is everything. For law enforcement, this means body cameras must be activated earlier in encounters to capture pre-force events. Reports must detail why certain tactics were chosen, not just what happened in the final seconds. Training must emphasize de-escalation and clear commands, knowing these will be replayed in court. For citizens, especially gun owners, this means recording encounters were legal, clearly stating intentions on camera, avoiding ambiguous movements, especially in high-stress interactions. Example: in Los Angeles County, a deputy encounters a legally armed homeowner responding to a noise in the yard at night. The homeowner's security camera captures the deputy failing to announce himself before shining a flashlight and drawing his weapon. A tense moment follows. Under the old rule, only the homeowner's final movement might matter. Under Barnes, the deputy's lack of announcement and approach style are critical contexts. Evidence is no longer just about the shot, it's about the story leading to it. Chapter 9: What to do now? Practical takeaways for citizens and officers. If you are a gun owner, disclose early and clearly if required by law. Narrate your actions. I am moving my left hand to my wallet. Avoid sudden movements. Keep hands visible unless instructed otherwise. Know your state's legal requirements cold. If you are in law enforcement, think about how your choices in the first minute will look in court. Give clear, unambiguous commands. Avoid overlapping orders with partners. Use lighting, positioning, and time to your advantage. A rare victory for context and common sense. The Barnes versus Felix decision is more than a legal tweak. It is a fundamental reminder that the Constitution protects people, not just moments. For gun owners, it means the law must see the whole picture, not just a frozen second that can erase your rights. California, Texas, Ohio, every state will feel this ruling. Cases that would have been dismissed will now see the inside of a courtroom. Officers will adapt, citizens will adapt, and the conversation about force, rights, and responsibility will evolve. On Firearms Law Advisor, we believe knowledge is your first line of defense. This ruling arms you with context, the most powerful weapon in a court of law. If you found this breakdown valuable, share it with a friend, post it in your carry group, and drop your thoughts in the comments. Stay informed, stay sharp, stay free.